Let's make you some money.
Right. So see, live started in. Hello, my name is Angela Owens with Phenomenal Business Solutions, and I provide accounting services and business advisory services to small businesses, currently with the emphasis on car dealerships. And today I am blessed to be joined by the wonderful probate attorney, LD Thomas. Would you introduce yourself today?
Well, thank you. Thank you, Miss Angela. I appreciate you. Thank you for having me, and thank you for putting this together and doing this. This is such good information, especially for such a targeted audience. As you said, my name is LD Thomas. I am a probate and estate planning attorney. My office is located here in Dallas, and we service people in Dallas, Fort Worth. Actually have clients all the way as far down as Houston. Um, I mentioned we do probate, estate planning, and heirship work. And I think for this particular call, we're going to focus probably more on the estate planning and helping people get their affairs in order. Like we've all heard that term, you have your affairs in order, get your stuff together. And that's what I do. I have my practice has been in existence in just under 5 years. So it'll be 5 years in November, and we have exclusively focused on this area, which has given us the ability to go deep into this area of law and understand the nuances, and I don't like to say tricks, but understand the nuances and all of the things that are at our disposal to tailor plans to clients that fit their specific needs. I think that is something that you may hear me you may see me repeat a couple of times as we talk, is even though estate planning is something everyone needs, everyone's plan will be different. Everyone's goals are different. Everyone's strategies should be different to match those goals. We have been blessed to be awarded different awards, Best Law Firm in Black Dallas several years, and a couple of other acknowledgments. And for us to have done that, we don't take that lightly. And we think a lot of that is due to our attention to detail and our customer service, and also a passion for what it is that we do. So I'm so excited. I don't know if you can tell, to be here and be able to talk to you about estate planning for car dealerships and business owners in general.
All right. Well, let's go ahead and get started with getting this information. So I'm gonna start with, as a car dealership, how can someone ensure a smooth transition of the dealership to their heirs or business partners during that untimely time that something happens to them?
Yeah, I think that's an excellent question to start with, because I think that is the ultimate question, right? How not only how do we transfer those assets, but how do we make it a smooth transition? And the very first thing you need to do is sit down with an estate planning attorney and come up with a plan. What that plan looks like will be different for everyone. For some people, it may be a trust. For some people, it may be just a will. For our car dealership and business owners, we have to take into account what your operating agreement with your partner says. Are you a sole proprietor? What's the structure of your business? And what do you want to do with your interest in that business? Do you only own 50%? Do you own 100%? Is it shared? What is that? And that'll kind of guide us along the path of what we can do and what's best for you. But in order to make sure that transition is smooth, whoever you're leaving your interests to, be it to your business partners, be it to your family members, or be it, or maybe you just want your interests sold and liquidated, and then the asset and the proceeds from that liquidation go to your family. Whatever it is that you want, in order to make that happen as smoothly and as efficiently and as cost effective as possible, you need to sit down with an estate planning attorney, let them know what your goals are, and craft that plan. So having a plan, having something on paper, tangible, that will help ensure that that transition is smooth, whether it is untimely, or something, that you may expect in, by the time you're 90 years old. Like, okay, well, in a minute, something may happen, right? So whenever that happens, to make sure that it is smooth, you have to have a plan, and the plan has to be on paper. Verbally communicating that to your loved ones is not enough.
And I know taxes is not your thing,
Mhm.
but what steps should someone take to minimize the estate taxes on
Yeah.
the business when it's transferred to the heirs?
Yeah. So you're absolutely correct. Taxes in and of itself, they are not my thing. I do know a wonderful tax person uh, that I can highly recommend. However, when we deal with estate planning, planning for potential estate tax exposure, that does kind of fall into my realm, right? So I'm not doing your taxes, but I can look and say, hey, your heirs or whoever you leave this to may be exposed to the estate tax, which is fairly high right now. It's about 40%. Now, there are a couple of things to consider right now, and this fluctuates. Right now, the standard federal estate tax exemption is around 13 million. Okay. So that includes everything that's in your estate, your house, your car, money on hand, and the total valuation of your business. Okay. Um, so if you fall up under that, your family's not exposed to the 40% sales tax. So the first thing that we need to do is we need to look at your balance sheet. You need to look and see what are you worth? What is your estate worth? And kind of get an estimate to see if you're close to that number or if you're above that number. Um, and again, you need to develop a relationship with an estate planning attorney. And I think we'll talk about this later on, because that 13 point million is not set in stone, and it changes. And there's a high likelihood that that will drop to about 5 million. So there may be some people listening and say, oh, well, with my dealership and all of the assets that it owns, my house, maybe I'm around 8 million. And so you're thinking, oh, well, he says the exemption is 13. That doesn't affect me. Well, if it drops down to 5 million, that 3 million that you're over is exposed to possibly being taxed at 40%. So the first thing you have to do is determine whether or not that's a question for you. If that's an issue for you. If it is an issue for you, if you're anywhere near, I would say even 3 million at this point, 2 to 3 million, because we don't want to be caught with our pants down. We want to start thinking about what are some strategies should that number change, and should you and your loved ones find yourself in that category. There are a number of things at our disposal to help with that, and that can help offset with that. One of the more common strategies is to anticipate what that tax bill would be. Okay. So we say, okay, we're this much over 40% of this, so on and so forth. And one of the things that we do is we set up what's known as an irrevocable trust. And I think we'll talk about the differences between revocable and irrevocable trust. Is we'll set up irrevocable trust and get a life insurance policy that is equal to or above, because it fluctuates, the amount of the tax exposure. So what will happen is upon your passing, that money will pay to that trust, and that trust is directed to pay any taxes. So it's kind of using life insurance to take care of that tax exposure, which takes the burden off of your family and then protects all of the things outside of that. So that's one of the strategies. There are some other things when it really happens to kind of, look at it and see if it's um, other ways to address that, but that's probably the most common and easiest way is to set up a separate trust, have life insurance, pay into that trust to pay for any tax exposure that your loved ones may have due to your estate.
Okay. And are there any risks associated with transferring the business assets into a trust? And how do you maintain control of the business while protecting the estate?
Yeah. So I mean, we're talking to business owners. There's inherent risk in everything, right? And so let's talk about exactly what a trust is, how it's structured, and what it does. Because I think understanding that foundation will allow us to have a more intelligible conversation about the risk associated with it. So a trust is an agreement. All right. There are three parties in a trust. There is a settlor, which is the person who establishes the trust. So theoretically, our car dealership owners, if they say, hey, I want to set up a trust as part of my estate, they're setting it up, they're the settlor. Then you have the trustee. The trustee is the individual or individuals responsible for managing whatever assets are in the trust. And then you have a beneficiary, the individual or individuals who benefit from the trust. So you have someone who sets up an arrangement for assets to be managed by someone for the benefit of another person. Now you have three roles there. And I say roles because those roles can all be one person. You can set the trust up, you can manage the trust, and you can benefit from it. Or they can all be three different people. You can set the trust up, have it managed by someone else for the benefit of your heirs, right? So there are all types of ways we can put those puzzle pieces together. So when we talk about the risk involved with that, it depends on how you structure the trust. Obviously, one of the biggest red glaring risk is who's managing the trust. Now, if you move your assets into the trust and you're managing it, that's great. But we also need to talk about successor trustees. If something happens to you, not just death, if you're just incapacitated, if you're just in the hospital for whatever length of time, and this person now has the ability to manage your assets, you have to make sure that it's someone that you can trust, right? They do have a responsibility to follow everything that's been outlined there, but some people take the risk and do things that they shouldn't do, right? So, having someone manage your assets, there's an inherent risk there. So I can't say that it's completely risk-free, but making sure that you pick the proper people to do that. Um, so there are some risks in using a trust, but you just have to outweigh the benefits of that. The thing about a trust is a trust only has control over what you put into it. Okay. So when we talk about, oh, I want to trust to manage my business, the business literally you have to transfer your interest into the name of the trust. So if it's shares, whatever your ownership interest is, it comes out of your name and goes into the name of the trust, and it is managed by the trustee. Now, typically, our settlors are the trustee, so they're still managing it. But with that comes certain requirements for notice and those sorts of things. So it's a little bit more red tape if you do that. And that's why there's not a one size fits all situation. I'm a lawyer. I get it. People avoid talking to lawyers. I think we're super, super expensive. Um, you know, Google and everybody else can tell me everything I need. And honestly, that's not the case. A lot of times it will confuse you because Google does not take into account the nuances of your situation and your goals. So I'm going to say this once, I'm going to say it twice, probably say it 3 or 4 times. It's important to sit down with an experienced estate planning attorney so that they can look at the totality of your assets, your business, your personal assets, and craft a plan that works for you and minimizes the risk that are inherent to your specific situation.
All right. And how long does the probate process typically take for a business, and can it actually disrupt operations during that time?
In the well, it is, anything has the potential to disrupt. I tell you what will really disrupt it is not having a plan, not knowing who's in charge, not knowing where the business is going, not knowing, who's going to own the business. That will disrupt everything, right? And I think it bears stating that your loved ones, your business partners, they will have to deal with this because you have passed away. So they're in the middle of grieving. So having a plan, a succession plan for your business, an estate plan, all of that helps them throughout that process, because to just leave with nothing in place throws absolutely everything in disarray. Okay. The length of the probate process varies. I will tell you, um, not having a will, not having a trust greatly exacerbates and greatly stretches out the timeline. And especially when you have and you own a business like a car dealership where there are employees, there are vendors, there are customers coming in every day. Like the business is not going to stop. So you need to shorten that transitional time as much as possible. And you do that by having a plan. And so when you say how long is the probate process, I'm going to give you the classic law school answer in that it depends. If you do not have a will in the state of Texas, if you do not have a will and you do not have a trust, and you just up and poof and fall out and you dead and gone and everybody says figure everything out. We're all familiar with the concept that, my family gets this, or my wife gets this, my kids get, the state of Texas, my heirs, In the state of Texas, yes, there are laws that determine what your heirs will receive. The issue is the state of Texas also has to determine, well, who are your heirs in the first place? People don't get to just walk in and say, well, this was my husband, this was my wife, or this was my dad, or this was my mom. There is an entire court proceeding that is called a determination of heirship. The court has to determine who are your rightful heirs. That process includes your family or an interested party hiring an attorney, the attorney drafting an application with all the facts of your life, where you married, who are your kids, da, 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 filing that with the court. Then the court has to appoint another attorney to do their own investigation, separate to what was filed. You have to find two disinterested witnesses that are willing to come and testify. There's an entire court proceeding. Did I mention that your family is also responsible for paying the other attorney? So now they're paying for the attorney that they hired, plus the attorney that the court appointed. Then there's a court hearing where your family has to go to court. The witnesses have to come to court, give testimony. The attorney has to file, the court-appointed attorney has to then file their findings. All of this just to say, this was my wife, this was my husband, these are my children, all just to determine who are your heirs. And then once the court determines who your heirs are, those are the individuals who have standing. And then they all have to get together and agree on who the administrator will be, who would be the individual responsible for transferring those assets out of your name into the names of the family members who would rightfully get them. I don't know about you, but my family members, we have trouble deciding who's going to make the macaroni and cheese for Thanksgiving, let alone who's going to be in charge of divvying up a business and personal assets, right? And so that prolongs the process. And let me say this, Back to the first step of determining heirs, you have to prove that this person is your mother or your father, and that's providing birth certificates and all of this documentation. So that, and all of that falls under the probate umbrella. Okay, so a lot of times when we hear probate took forever, probate took us 2.5 years, a lot of times that's because it falls under that umbrella of the person not having a will or trust in place, and they have to go through all of those steps. All right. Conversely, with a properly drafted and properly executed will, we can get through the probate process and probably in Dallas, probably about 2.5 months. And the longest portion of that is just getting on the judge's calendar. They're very, very busy in Dallas. And so sometimes they book hearings out a little further. But the process, when you have a properly drafted will, your executor gives the will to the attorney reviews it, files the application, surrenders the will to the court. Notice is given, public notice for about 10 days. And then we're able to set a court hearing. And throughout that time, the only person that has to go to court on that day is the executor. They take the oath and they get letters, and then they're able to transfer those assets in accordance with what's in the will. In a properly drafted will, you list, I'm married, I'm not married, this is who I'm married to, these are my kids. So all that stuff about who your heirs are, it's already done. And so it shortens the process. One of the things that is always funny to me, and it's almost like a light bulb that goes off with people, is a will and a trust not only gives you the ability to say who gets what, it also gives you the ability to say who doesn't get anything, right? I mean, if we are being realistic, there are some strained relationships amongst family members or even business partners, right? So it also gives you the ability to say, hey, I want this person to get this, and I'm purposefully not leaving this person anything.
Okay, and I believe you just answered the question I was gonna ask next about avoiding.
Probably. I was talking a lot.
Yeah, so I think at the end of it, you were saying that if you have the will and everything drafted, then you can avoid having to go through that probate process because you've already.
Well, let me be clear. It avoids going through the determination of heirship process.
Oh,
So it still goes through the court proceeding, and that still falls under the probate umbrella. And you still go through probate, but it is nowhere near as long, drawn out, drastic, and dramatic as if you don't have a will. So you still go through probate court, but it's much shorter, much quicker, much more efficient, and less cumbersome.
so probate is it avoidable?
It is. It is. And one of the biggest tools used to avoid probate, because there are several tools at our disposal to avoid probate. The biggest is using a trust. So, as I mentioned earlier, a trust has control over the assets that you put into it, right? And remember, I said we take those assets out of your name and put them in the name of the trust. So, whereas when you pass away and you have a will or you don't have a will, we have to transfer those assets out of your name at the time of death. With a trust, we're transferring those assets out of your name while you're still alive. And so, if you have absolutely no assets in your name that are probatable, all right, so we have probate and non probate assets, and we can kind of talk about that. So, if you have no probate assets in your name because you've transferred them all into a trust, then you do not have to go through the probate process. I want to put a star, an asterisk next to that, a caveat to that is it is very difficult to know absolutely everything that you are going to own and that will be in your name at the time that you pass away. Okay. So any estate planning attorney worth their weight, if you're going to use the trust as your primary estate planning document, they are still going to recommend that you have a will. So it does not eliminate the need for a will. It does, how putting everything in a trust, however, does minimize the likelihood of having to go through probate. What you will do in your will, you will have, if you use a trust as your primary estate planning document, you will have a special type of will, or you should have a special type of will that's called a pour over will. And it simply says, if there's anything that I did not get to put in the trust for whatever reason, pour it over into the trust and let the trust do whatever it's supposed to do. Again, simplifies the probate process, but it is crucial and key. Reason being, like I said, we don't know the circumstances in which someone may pass away. And so if your family needs to file a wrongful death lawsuit on your behalf, or you're in the middle of a lawsuit and you win and the money comes in, well, the money is going to be made out to your estate, not to the trust. And so you have to have a will, because the will is going to govern your estate. And so that pour over will say, hey, that check that just came into my estate, pour it over and put it into the trust. So it's making sure that all of our bases are covered to make sure that the trust still governs what happens.
Okay.
And that's what the internet is not telling you. And that's why it's important to sit down with someone and have those conversations so you can make sure that you have all of the cogs in the wheels going the way that and working the way that they need to.
And this is something I'm probably gonna do a little more research on, because with the dealership and all the regulations and stuff, but just generally speaking, how does one make sure that their dealership can continue to operate during the probate if they pass?
Yeah, so a lot of that is going to be determined by your operation agreement that you have for your business, right? Any business owner should have some sort of succession planning. Even me, even you, if something were to happen, this is who kind of steps in. That's number one. And that's going to be the best thing, is having a succession plan for your business. The operation of your business and the ownership of your business are kind of two different things. A lot of times, because we're doing, we're the ones doing the operating and the owning and the work and the marketing and the everything, our lines get blurred. But the operation of the business and the ownership of the business are two different things. So to make sure that the operations continue, you need to have some sort of succession planning in place to keep that open, because you can leave the business to your spouse or to your children or to whomever, and they can own it, but who's running it? And sometimes those are the same people. Sometimes we have family members that are working in those capacities, but it needs to be clear. One of the things, and this is a great opportunity to bring this up, estate planning is not always and only about when you die, okay? Having a proper estate plan also includes documents in the event of your incapacity, right? Things could happen. You could be in the hospital for a couple of months and make a full recovery. And when you make that recovery, you're going to want to come back to a fully operational business. So there are documents that are necessary in your estate plan to keep your life operational, much like how you want to keep your business and your car dealership operational. So we need to make sure we have a power of attorney. Okay, a durable power of attorney allows someone to transact business on your behalf. A medical power of attorney. If you are in a position where you cannot make medical decisions for yourself, who do you want to make those medical decisions for you? A HIPAA form allows your doctors to discuss your medical information and release your medical records to whomever you put on that form. Hopefully, it's the person who's making the medical decisions, because that just makes sense, right? If you're making medical decisions for me, I need you to know everything that's going on. So those operational agreements and then those other documents to make sure that things and people have the authority to talk to banks, to talk to vendors, to talk to whomever you have the authority to. If you are incapacitated, that those documents need to be in place. So that's where kind of the estate planning and some succession and operational guides kind of merge and come together to make sure that those people have the authority that they need to transact business while you are out, hopefully just temporarily.
Okay. And how do you ensure that the estate plan accounts for the different roles that family members might play in the business?
Yeah, that goes back to sitting down and honestly developing a relationship with your estate planner. It's important that you get with someone knowledgeable and that you're comfortable talking to. Hopefully, that's me. But you, you have to communicate what your goals are. I mentioned this when we first started this conversation. Everyone's goals are different. Everyone's family structure is different. Everyone's family makeup is different. The integration of family members into their business looks different for everyone. So that's why it's important. If you want to ensure that all of that is taken into account, you just sit down, have an in-depth consultation, in-depth drafting process to incorporate that because it looks different for everyone. So much like you need to advocate for whatever your goals are, those are the things that you communicate to your estate planning attorney, and they will talk to you about the ways to make sure that that happens, whether it's uh, updating that succession and operational agreement, whether it's making sure that this person is the power of attorney or the successor trustee, if we've gone the way of the trust. It all looks different depending on what your estate plan is, but you'll never get that goal if you don't communicate that that's what you want. And so communication and the relationship with an estate planning attorney is key to that.
Okay. And then what is your approach to balancing the interest of the business with the personal estate?
Balancing the interest of the business versus the personal estate plan, I think they work together, right? They're all, nothing supersedes the interest of the client, right? And so the business owner is also the person in the family. They're the mother, they're the father, right? And so the client coming to me has all of these different entities pulling at them that they want to make sure are covered and taken care of. And so it's not the interest of the business, it's not the interest of the family. Honestly, it's the interest of the person that's sitting right in front of me. And what is it that is going to give them the greatest comfort and peace of mind? And what is it that they are most concerned about? For some people, they're more concerned about making sure that their family is financially secure. And so for them, it's like, actually, I'm the only one that knows how to run the business, da 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 da. I'm gonna, I don't want it to continue. So let's talk about liquidation and then managing those assets for your family members. For other people, this is my legacy. My son is now working for me. My daughter is running this aspect of the business, and I want to make sure that it continues. So those are different goals. So those are competing interests. So it all depends on what's important to the client, and then we'll craft a plan that balances accordingly.
Okay, so with that being said,
Uh-huh.
okay, so a husband and a wife,
Okay.
should they develop, should they have their own separate plans? Because a lot of their stuff is gonna overlap.
When you say develop their own separate plan,
Should they have a separate estate plan or?
yeah, yeah.
Okay,
To a certain, so there are some things that you can do together, and there are some things that really need to be separate. Okay. So every individual needs to have their own will, period. They need
okay,
to have their own will. Because it's, I mean, sometimes people perish together, in this whole notebook moment, I guess.
but
Uh,
most times they
or
don't.
sometimes it's, something more tragic than that. But typically, you're not going to pass away at the same time. Okay. So you need to have a separate will. And even as business owners, yes, you may have some things that, oh, if you guys own the business together, there may be some things that overlap, but your personal property is different, right? And so, you know, his baseball card collection and her, I'm not going to try to be sexist, her baseball card collection, right? Anybody's baseball card collection, whatever those personal items are, they're your personal items and you can decide who they go to. So as much as you guys are living together, working together, developing business together, there's still parts of your life that are separate and that are considerations that you probably may not pass at the same time. So you do have to have your own will. Again, and then also those other documents, medical power of attorney, durable power of attorney. Even as husband and wife, I counsel a lot of my clients who are husbands and wives, and they say, well, my spouse is my next of kin. Why do I need this? Heaven forbid you guys are in a car accident together and you're in operating room A and your spouse is in operating room B, right? Well, who's making the medical decisions then? So that document allows you to not only, if you want to, put your spouse as the primary, but if they're unavailable, then who speaks for you? Who do you want to advocate for you? And the same for a durable power of attorney. So each one of you needs to have a set of those documents. Now, where we can start to come together is a lot of times husbands and wives can have one trust. So both of you can set up a trust, transfer your assets on it, because a trust does give you a little bit more flexibility to say, okay, when I pass away, if I pass away first, then this is what happens. If they pass away first, then this is what happens. And then so on, because we don't have to go through the court proceeding. It's trust exist outside of the court process and avoid probate. But if you have a will, if you do not have a trust, everyone needs to have their own separate will documents. Do not do joint wills. That complicates the process. People, that's a whole nother thing. But you can do two settler trust, two-party trust. So that's not, you have two wills and one trust. But we're not doing one will. We're not doing one will.
Okay. Okay, so how often should someone update their estate plan as the dealership grows or family circumstances?
Right then and there, those examples that you gave are excellent times and opportunities to reevaluate your estate plan, but you should do it periodically. Okay. Number one, if you have any major life event, you should take that opportunity to look at your estate plan and make sure that it is still effective. And still reflects your wishes. People are getting married, people are getting divorced, people are passing away, people are having babies, right? You can have a baby. Now you have grandchildren, or all of those sorts of things. And there are new people that you may want to include, and there are people that you may want to exclude. Purchasing new homes, new property, any type of a major purchase that you may want to leave to someone, that's a great indicator that we need to look at this estate plan and just make sure that it still reflects. As your business grows, again, it's always great to look at that. Also, changes in the law. Talked about it earlier. When we start looking at changes in the estate tax exemption, that's a huge trigger, because what we plan for then, you may now be in a new tax bracket, or you may now be exposed where you weren't before. So you do want to look at it periodically, at least just once a year, just double check. And then if something happens throughout that year, you want to examine it as well.
And do you provide ongoing support and reviews?
I sure do. I should. My clients, I sure do. I sure do. We try to keep them abreast of what's going on. We do reviews. A lot of them follow us on social media. And so, when they announce, oh, we just got a new baby, oh, we just got, this set of thing, it's a reminder. Hey, do we need to make an adjustment? But of course, there are always those soft touches that we have throughout the year, like any business owner, an email here, email there, just a reminder. Hey, but yes, we do provide that, and that's the thing with me, how I approach estate planning and how I hope the estate planner that you work with approaches it is a relationship. It is not a one time, okay, I'm done. Okay. No, we can get you covered and we can give you some peace of mind and you know things will happen. But again, as your life changes, we may need to update that. So it is a relationship. Now you ain't gotta call me every day. You gotta talk to me every day. But it is someone like an accountant that you're going to want to have on your team. You don't change financial advisors every time you need to buy a new stock, okay? But you do over time develop that relationship, and that's your go-to person. And you just need to add an estate planner to your team. They need to be on the roster, as the kids say.
Okay, and then I might annoy you a bit with this one, but let's say somebody says, I could just go do this myself on legal.
Mhm. Listen, I tell you what, I told somebody I will vacuum all the sand off of Miami Beach before I did an online will. Okay. Reason being is all of the nuances that we just talked about, you don't get that. Okay. You get how many kids you got, what you want to do, da 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 da, and it spits something out. I have had to correct and fix so many wills that were done online, and people are thinking that they are saving time and they're saving money, and they are not. A lot of times, the wills don't actually do what you think they're going to do. You have to be cautious because estate planning is state specific. And so the laws are state specific, and you're dealing with this national website that's trying to put out something that, uh, kind of is all encompassing for all states. And they say, oh, well, you can pick this and it'll be a Texas will or whatever. The Texas legislature meets every 2 years. The laws change. Uh, it's just as hard as people have worked for their business to create a legacy, to take care of their family. I just don't know why we would skimp on making sure they're covered. A will speaks for you when you can no longer speak for yourself. It takes care of your family when you can no longer take care of them. And to go online and just click a couple buttons, all right, do that. That seems very haphazard and counterproductive to me. So I don't recommend them. I mean, that is real. I mean, it's what I do. So obviously, I'm not going to recommend them. But there are some inherent issues with them. The lack of knowledge, the lack of support, the lack of crafting a plan that is tailored to you. I've said it over and over. Everybody's different. How is this nameless and faceless entity going to take into account and talk to you about whether or not, well, if you have a child with special needs, maybe we should talk about this. It just doesn't. It honestly just does not. And I think it gives a lot of people a false sense of security.
Yeah.
And if not done properly, it could end up costing your family tons of money. The average cost of probate litigation when people are questioning the validity of a will in Texas is around $250,000. I am not charging you $250,000 to draft your will and sit down and have this conversation with you. So, for obvious reasons, I mean, it's what I do. So, no, I don't particularly recommend them. And like I said, I have had to fix so many of them. I've had to fix a great number of them uh, because the other part isn't just drafting, it's proper execution and making sure that the documents are signed appropriately.
Okay, well, that is all that I have for you today. So if somebody
That's it.
wanted to reach out to you, what's the best way for them to do that?
So there's a number of ways. We have a website and it's LD Thomas Law. At this very moment, it's under construction, but there's still a little contact button, so you can contact us there. So go there, you can contact us, and we can set up a consultation and set up a chat. You can email me directly, because if you looked at this, you get personal access to me. You can email me directly at ld@ldthomaslaw.com. And obviously you can call the office at 945-235-2868.
All right. And I will be adding this information to the comments after the live so that you can have that information and be able to reach out and ask some questions and get your own consultation set up.
Yeah.
And I really appreciate you for joining me today,
I
LD.
appreciate the invitation. Thank you so much. We have to do this again because there's so much more. But yeah, thank you for the invitation.
No problem. And we are signing out.